Hello and welcome to India Tonight. I'm Karan Thapar. With questions continuing to be raised about P. Chidambaram's alleged role in the 2G scam, we ask how credible is the claim that he should be charged under the Prevention of Corruption Act? And has the recent trial court ruling on charges weakened that argument or corroborated it? My guests are former Attorney General and Solicitor General Soli Sorabji, the Vice Chairman of the Law Commission KTS Tulsi, the Editorial Director of the New Indian Express Prabhu Chawla, and one of the key petitioners in the 2G case, Subramanian Swamy. Gentlemen, let's start with the argument put forward both by Subramanian Swamy as well as the leader of the opposition in the Rajya Sabha, Arun Jaitley. KTS Tulsi, they say that when Mr. Chidambaram gave up his initial position in favor of an auction and accepted Mr. Raja's stand in favor of first come first serve at 2001 prices, he knew he was facilitating an unjustified pecuniary advantage to the licensees, and therefore he is guilty of breaching section 13(1)(d)(2) of the Prevention of Corruption Act. Do you agree with them?
Not at all. Merely making a policy decision about whether it should be the auction route or it should be the route in accord as advised by the regulator, and that's a TRAI. And if he agrees with a particular view, there can be so many valid reasons, and therefore you can't say that merely because he changed his position or merely because he agreed with the telecom minister, therefore he is liable. There is no material, what to talk of, prima facie material for the purpose of investigation.
Alright, Mr. Sorabji, let me quote to you a very different view given to Network 18 by Harish Salve. He said, I would be very uncomfortable if I were in Mr. Chidambaram's shoes. Who do you agree with, Harish Salve, who says he would be uncomfortable, or do you agree with Mr. Tulsi, who says that both Subramanian Swamy and Arun Jaitley are mistaken in believing that Mr. Chidambaram can be charged under the Prevention of Corruption Act?
Well, Karan, I can't talk about Harish's discomfort, that maybe different levels of discomfort is feeling, but I'm inclined to agree with Tulsi, because he said there may be valid reasons. I go one step further. Assuming there are not valid reasons, is there his reason, is it tainted by malafidis? Could it not be error of judgment? If you are going to ask for prosecution of ministers because they take a certain point of view which by hindsight may not have proved to have been the correct one, I don't think we would prosecute them. There must be cogent, credible material. You can't problematic inferences from incomplete facts. It's not sufficient to implicate any person, any minister.
You have two very interesting but opposite views to yours. Mr. Tulsi, who says there are perhaps cogent reasons for Mr. Chidambaram changing his opinion and accepting Mr. Raja's position. Mr. Sorabji, who advances the argument that it might possibly have been error of judgment, but it's not mala fide. Both of them disagree with you. How do you defend your position?
Well, first of all, it was not my position. I didn't want to interrupt you. I never said that he made a change in policy. That is Jaitley's view, and it certainly, if there is a change in policy, it doesn't come under immediately under 13(1)(d).
So you then disagree with Jaitley's view? You don't?
I don't know. I don't pay attention to that. It's not material for me. What's material for me is that the price was fixed at 2001. Who fixed it? Two, that the people who got the licenses, although there was a try and there was a license requirement not to sell it for 3 years, by a certain sleight of hand, Mr. Chidambaram advised Mr. Raja, and that's on record, that he could sell it, he could allow them to sell it to Etisalat and Swan to sell it to Etisalat and Unitech to sell it to Telenor, and they earned a whopping 8 times what they paid the government of India. So therefore 13(1)(d) comes in because there was without any public interest, and certainly there was no public interest because these are blacklisted companies. He enabled them to make a lot of money.
All right.
That was my charge.
Okay, so your charge is not that Section 13(1)(d) comes into play because he changed his position.
Yeah.
It comes into play because he facilitates sale of shares onwards.
Onward, and plus this fixing of the price at 2001.
Prabhu Chawla, you've listened to all three lawyers. You're a journalist and editor who's followed this story very closely. What is your reading of Mr. Chidambaram's position? Would you agree with KTS Tulsi and Soli Sorabji? Or would you agree either with Harish Salve, who says that he would be uncomfortable if he was Chidambaram, or with Mr. Subramanian Swamy, who says that 13(1) does apply but for a different reason? Which of the two do you agree with?
Colonel, I admire Subramanian Swamy for fighting a lonely battle. Because of him, the issue is still alive, otherwise this would have been buried by now. The question is, who will decide who is culpable? Can media decide? Let it be decided by the court. The question is, courts have taken cognizance of the fact. Mr. Subramanian Swamy's appeal is also pending in the court. Let the courts decide. When we talk about culpability, you must remember one thing. It's a collective decision of the cabinet. If Mr. Chidambaram changed his mind, so did the Prime Minister's office. On 6th of January, Mr. Pulak Chatterjee wrote to the committee.
Let's not go on to the Prime Minister.
Let's take the spectrum should be given to.
Prabhu, I'm stopping you. Let's not go on to the Prime Minister. I want to keep the focus on Mr. Chidambaram.
I'm speaking of Mr. Chidambaram.
Go ahead.
No, why not? When you are, the question is, you have asked me Chidambaram is being made accused because he was involved in taking decision making, which was endorsed by the Prime Minister's office later on.
Okay.
The question is, who will decide? I am saying whether Chidambaram is culpable or not. I am not giving any kind of opinion on that. I am saying, let the agencies, let the court, let the highest Supreme Court decide whatever the crime has been committed.
Okay, I accept that.
Decide on that.
I understand your reluctance. I understand your reluctance to give me an opinion, but when you say let the courts decide, of course the courts will decide. It's not a question of us letting them decide. They will decide. They have a right to decide. Let me come back to you, Mr. They will decide. They have a right to decide. Let me come back to you, Mr. Tulsi, and take up the point that Mr. Swamy made, that he believes Mr. Chidambaram can be charged under Section 13(1)(d)(2), but not because he changed his view for mala fide reasons and thus permitted an unjustified pecuniary advantage, but because he permitted the onward sale of shares, which
and the price
at which that happened.
Now there is no sale of shares, because it's only when these companies, according to whatever material is available in public domain, these companies at the time of giving an application said that they will bring in foreign equity and for the purpose of discharge of rollout obligations. And if you issue fresh equity with government's permission, it cannot be termed as the sale of sale, and the money came through banking channels with the approval, with the prior approval of the government. So therefore, what is it? Which false statement have they made? They told the government right in the beginning, we will bring in fresh equity. And we need to remember that in India, under this policy, the existing operators were ineligible. And persons who, if they are ineligible, the foreign operators are ineligible, who will come? Only those persons who are not in telecom sector. And when they came, they said that we were coming in with the intention of bringing in experienced telecom operators from abroad. And when they come, it's actually a lot of foreign investment having been made in the telecom sector in India. India should be happy.
I accept that. That's your answer. Let me put the very same question to Mr. Sorabji. Mr. Sorabji, how do you respond to Mr. Swamy's claim that Mr. Chidambaram can be charged under Section 13(1)(d)(2) of the Prevention of Corruption Act, not for changing his opinion and facilitating a pecuniary advantage, but because of the sale of shares?
Karan, the very critical expression in Subramanian Swamy's statement was, he did by sleight of hand. Now that's the thing, sleight of hand. Where does he get it? How does he presume? How does he infer? That's the whole basis. That means he's going on the position that it is a mala fide act.
Absolutely.
The expression sleight of hand means what? Means it was for extraneous reasons, it was a mala fide reasons. Now there is no material at present to establish that.
Let's put that to you. Where do you come up with that phrase sleight of hand? What gives you the justification for using it?
Well, I'm thankful to Sorabji. He is as sharp as ever. That's fact. I did say sleight of hand, And the
But
fact
why did you say it?
I'm telling you, I'm going to tell you now. Tulsi says it's just bringing in fresh equity, creating fresh equity. Actually what has happened is Swan Telecom's name is changed to Etisalat, and now Etisalat DB has become a branch of Etisalat in Dubai. Telenor, Unitech has become Uninor. So therefore, how is it that these companies have changed the management hand?
This is sleight of hand?
Of course, because if you're just selling equity, you'll still be Swan Telecom and you will be still Unitech.
No, but if you happen to sell the majority of the equity, then the new buyer has the right to change the name.
That is precisely.
But you've sold the majority not by selling your own share, but by diluting. That's the critical
point. It doesn't
point.
matter. Once the company goes into the hands of these two companies, the license is also there.
So you consider this sleight of hand. This is your reason.
Of course,
okay.
It is my reason.
Let me bring you in, Prabhu Chawla. Do you think that really does amount to sleight of hand, or is this some exaggeration of expression instead?
My dear Karan, you allow me to complete the sentence, because FIBV is there, in which all the secretaries of the government of India are represented. There is a secretary, joint secretary representing Home Ministry, there is a joint secretary representing External Affairs Ministry, there is a joint secretary from Commerce and Industry Ministry. All of them get their instructions from their own minister. Once the secretary FIB passes the resolution allowing the disinvestment, only then the minister approves. Does it mean all other ministers whose the joint secretary was representing the FIBB, they were the part of the sleight of hand? The question is, FIBB is a statutory body which takes a decision approved by the cabinet, therefore everything was allowed. It was a CCA decision earlier, which means presided over the Prime Minister, which allowed this kind of disinvestment earlier. The joint secretaries who were present in the meeting, who allowed this investment after these companies got the licenses, they were taking instructions from their own ministers.
Okay.
It was the implementation of a policy, which Mr. Chidambaram only signing once the recommendation had come from there.
Absolutely.
Only the misuse were done by Mr. Raja, who misused the queue system and manipulated the system, therefore is being charged.
Okay, that's a very good convincing answer from Prabhu Chawla. You nodded your head saying you wanted to intervene. Very quickly, what's your response?
No, it's not a convincing answer as far as I'm concerned. I mean, he's a sharp cookie and he can give any argument.
Sharp cookie can be a compliment as well.
Well, of course it's a compliment. He's an old friend of mine. I'm bound to compliment him. The question is this, that there are two parts and you're concentrating on one. One of them is that these two companies were blacklisted companies. There is a letter from the Home Ministry when Shivraj Patil was Home Minister to Mr. Chidambaram that under no circumstances any financial transactions should be permitted.
We're talking about Etisalat and Telenor?
That's right.
Okay. So in other words, this adds to your sleight of hand?
Exactly.
Okay.
Not only it adds to my malafide.
Okay. And malafide underlies your sleight of hand.
And Mr. Raja has recorded on the file that is Mr. Chidambaram who told me this can be done. Secondly, I must come in defense of the Prime Minister.
No, leave the Prime Minister. They're not criticizing the Prime Minister. No, they're not criticizing. I stopped Prabhu Chawla. I stopped Prabhu Chawla. Very quickly on this particular point that these were blacklisted companies and yet Mr. Chidambaram permitted sale of equity to them. Do you want to answer that, Mr. Tulsi, before we take a break?
Well, so far as I know, the question of that was posed to Mr. Chidambaram was only whether transfer of equity or issue of equity is permissible, is legally permissible, and it is only that issue which was in principle permitted or approved by Mr. Chidambaram. It is not a question as to who is transferring. The individual cases were different, but in this case he said that transfer of equity, there was no such representation that there will be no transfer of equity.
Okay.
In fact, the applicant said that we will transfer equity.
Let me bring you in, Sorry Sarabji. As you've heard Prabhu Chawla say, the FIPB would have presided over and taken the decision which cleared the onward sale of equity. Therefore, surely if this has been sold as is alleged by Mr. Swamy to companies that were blacklisted, the responsibility lies not with the minister but the FIPB. Wouldn't you accept that?
I find force in Prabhu's argument. And besides, when you're talking of sleight of hand, not sleight of hand of those companies, sleight of hand of Chidambaram to make him answerable to criminal charges. Let's not mix up the two.
Okay. So you don't buy that argument either. Very quickly, Prabhu, before I take a break, how do you respond to what you heard Mr. Swamy say that these were blacklisted companies? Give me a short, sharp answer.
I am just giving short answer because Joint Secretary Home Ministry was in that meeting. He was not listening to the minister, it seems, because his signatures are there on the approval of the transfer of equity.
So in other words,
I don't think who is powerful, Joint Secretary of a ministry or a minister himself who has eased out after that.
so in fact, as you say, it is the FIPB that takes responsibility. You can't pin the blame if there is blame to pin. That's a very important codicil on Mr. Chidambaram. We take a break at that point, and when we come back, we ask, has the recent ruling by the trial court judge on the charges corroborated the alleged case against Mr. Chidambaram or weakened it? See you in a moment after the break. Welcome back to India Tonight. We're discussing the allegations against Mr. Chidambaram and his supposed involvement in the 2G case. Dr. Swamy, let's ask the question where the trial court's ruling on the charges leaves the so-called case against Mr. Chidambaram. At one level, the ruling says that this is a problem not to do with policy, but with the implementation of that policy. Therefore, prima facie, that suggests to me that the questions that are being asked about why Mr. Chidambaram gave up his stand in favor of an auction, and I accept that those are not your questions, those are Arun Jaitley's questions, but sticking to that, would you agree that those are now irrelevant and invalid questions?
Absolutely. Their question, first of all, let me tell you, there is no such thing as policy being the prerogative of the government. There has to be a choice on the basis of rationality. You can't have an arbitrary choice, a malified choice.
That apart.
Yeah, so don't bring this policy question each time.
So you agree
policy is irrelevant here.
But let me just clarify one thing.
Yeah.
You began by saying that the fact that the trial court judge has said that policy is not an issue means that Arun Jaitley's questions, in your eyes, are irrelevant and invalid.
Absolutely. Arun Jaitley is half-cocked thing. You see,
Arun Jaitley is half-cocked.
Yes.
Okay. KTS Tulsi, let me put this to you. I'm going to quote from what the trial court judge said in that ruling about charges. He says, the policy is not in dispute in the instant case. The prosecution is about the subversion of the policy by the accused persons with dishonest intention. Does this therefore lead to the conclusion that Mr. Swamy agreed with, that Arun Jaitley's questions regarding why Mr. Chidambaram changed his position are irrelevant and invalid?
Well, that means that if the policy is not the question, then what's the question? Even the question of loss of 1,70,000 crore is gone out of the window. When the trial court itself says that there may be a loss of 30,000 crore, so 1,70,000 crore is out of the window. And even with regard to 30,000 crore, the trial court perhaps itself says that it's not, the question is not of loss, and the quantum of loss is immaterial.
Can I stop you?
If the quantum of loss is immaterial,
can I stop you there?
What are we talking about? Unless, according to me, there is illegal gratification involved.
That's right.
You will not be able to
can I stop you, Mr.
charge
Tulsi?
anybody.
You're actually going beyond the remit of the question I asked. You're actually questioning whether even a case of conspiracy in terms of implementation can be made if there is no loss. And that's another issue altogether. Let me come back to the question I asked. If the trial court judge in his ruling about charges says that there was nothing wrong with policy, then does that mean that Arun Jaitley's questions about Mr. Chidambaram changing his position from auction to one in favor or one accepting 2001 prices, those are invalid and irrelevant questions? Would you agree with that or not?
Absolutely. The question, if the role of Mr. Chidambaram, even according to the note of the Ministry of Finance, which is the new document according to Dr. Swamy, even according to that note, his role is confined to the policy, not the implementation of the policy.
Absolutely.
Implementation was by the telecom minister.
Absolutely. That is a very clear answer. Now, I'm going to leave you out for a moment. I'll come back to you later, Dr. Swamy. Now, there is, of course, Mr. Surabji, another element of that ruling on charges, where, in fact, the trial court says, and I'm going to quote the trial court, it may not be possible to say that pecuniary loss has been caused to the state exchequer, though it may be apparent that undue pecuniary advantage has been gained by a public servant or private person due to misuse of office or due to corrupt or illegal means. Now, going by this, where it is apparent or may be apparent that undue pecuniary advantage was conferred, doesn't that in a sense corroborate Arun Jaitley's argument?
Karan, on principle, I don't want to refer to Arun Jaitley all the time. He is not with us. I will have him with us. No use saying Arun Jaitley said this, said that. He may have his explanation. That apart. I don't think really we must read too much in the judgment to come to a definite conclusion that really helps or does not help. Chidambaram's case, Mr. Chidambaram's case will have to be decided on its own facts. Of course, their observation about policy is relevant, but when you are reading all these things you pointed out again and again, please remember that there should be cogent evidence. We can't go on suspicion, can't go near surmise, can't go near conjecture. Otherwise no minister will be able to function. That's an important thing to remember, because you are implicating him in criminality, not in any civil action for damages or negligence. That's important, and not only Chidambaram, that applies across the board to any minister.
Okay, in which case...
In other words, we must have credible, cogent material, not mere surmise, conjecture, suspicion.
Prabhu Chawla, you're a journalist. This is a very technical issue, and secondly, it's an issue that hinges upon an interpretation of the law, which for most laymen is very difficult to do. As a journalist, give me your sense and give me a quick answer. Does the ruling about charges weaken the case or strengthen the alleged case, and I use the word alleged, against Mr. Chidambaram? A quick answer.
As a journalist, I believe in full faith in judiciary. I cannot selectively use one part of the judgment to support my hypothesis that he is right in case of Raja, but he is wrong in case of Chidambaram. I must judge the judge on what is written. He has not found any evidence against Chidambaram so far. If he finds, definitely he will pass an appropriate order. The question is, we should refrain from discussing the judgment in parts and quoting somebody else. The question, and Subramanian Swamy was another boardless minister when he was a minister.
Okay.
He took certain decisions which people may not have liked at that point of time. I don't want to quote those examples, because the minister was there to take some decisions on the part of, because Government of India business conduct rules give them certain powers. If they use those powers without any evidence they have not been misused, I don't think we can play with any part of judgment. The judgment has been delivered by Mr. Saini on the basis of facts made available to him. I think we must leave it there.
Okay.
That's why we cannot discriminate with one part of the judgment, okay, and I disagree with the second part of the judgment.
You've taken the words right out of my mouth. We must leave it there, and that is exactly where this particular episode is going to leave it. My thanks to Mr. Swamy for coming to studio. My thanks to Sori Sorabji, KTF Tulsi and Prabhu Chawla for joining me from their respective offices. And if you have been, thanks for watching. Goodbye. Good night.